Ladies and gentlemen, boys and girls, hello, namaskar, and welcome to Law Charcha. Today, we are going to discuss Bhartiya Nagarik Suraksha Sanhita 2023. This is a new law which came into force from 1st July 2024. It replaces the Code of Criminal Procedure 1973. So the Code of Criminal Procedure 1973 stands repealed now, and we have to follow Bhartiya Nagarik Suraksha Sanhita 2023 from 1st July 2024 onwards. It's in short form known as BNSS. So BNSS has a very unique object and reason. At least I have come across such objects and reasons for the first time. Not every law contains slogan of or a government's political slogan which finds mention in the objects and reasons of BNSS. So the government's political slogan of Sabka Saath, Sabka Vikas, Sabka Vishwas and Sabka Prayas is referred to as a mantra in the objects and reasons of this act. Now, if we see the literal meaning of mantra from the Cambridge Dictionary, it means a word or sound that is believed to have a special spiritual power, a word or phrase that is often repeated and expresses a particular strong belief. So this is for the first time I have come across such kind of usage in objects and reasons of a law. Further, if you notice from the objects and reasons, the entire focus of BNSS is on speedy justice, use of technology, use of forensic science, time-bound investigation and trial, use of digital means, and to have a citizen-centric approach. Especially the citizen-centric approach is noticeable even from the title of the enactment. If you notice, unlike the Code of Criminal Procedure 1973, the BNSS is titled differently, Bhartiya Nagarik Suraksha Sanhita. If you translate it to English, it would mean Indian Citizens Protection Code. Pertinently, you won't find any mention of a word similar to the procedure assigned in the title. Although primarily, if you notice or if you observe, in fact, it is a procedure code. As per its statements or objects further, if we notice, as I have already said, the focus is on avoiding delays in delivery of justice, pendency of cases, low conviction rates, insufficient use of technology, etc., etc. Now, all these challenges were there in the earlier times also, and the statement of objects and reasons of the old code also refers to these challenges. The statements of objects and reasons of old code were adopted for certain recommendations of Law Commission report, which seem to have inspired the objects and reasons of BNSS also. For instance, let's see, the first was an accused person should get fair trial in accordance with accepted principles of natural justice. Second was every effort should be made to avoid delay in investigation and trial, which is harmful not only to the individuals involved but to society. Third was the procedure should not be complicated and should, to the utmost extent possible, ensure fair deal to the poorer sections of community. Now, so far as the technology is concerned, statement of objects and reasons to the 2009 Amendment Act of the old code had also noted the need of technology. It was stated that the application of technology in investigation, inquiry, and trial is expected to reduce delays, help gathering credible evidence, minimize the risk of escape of the remand prisoners during translate, and also facilitate utilization of police personnel for other duties. Some provisions in BNSS are targeted towards effectuating those objectives, which were in the 2009 Amendment Act. If we move forward to certain provisions, to begin with the definition clause, audio, video, electronic means finds place in section 2 of BNS. It refers to the use of communication device in investigation amongst other utilities. the definition thus is kept more inclusive. The state governments are given the uh, responsibility of framing the rules for use of such audio video electronic means. Under the section 2I of BNSS, electronic communication is defined, which, like the definition of audio video electronic means, was not part of the old code. A pertinent change is brought in procedure of service of summons in section 64 of BNSS, which corresponds to section 62 of the old code. Provision is made for service of summons via electronic communication. The police station or the register of the code is expected or is required rather to maintain a register to enter addresses, email addresses, phone numbers, and other details of person to whom the summons is required to be served, and those rules are to be prepared by the state government. So in this section also the state governments are given responsibility to frame rules. A clarificatory change is also made to section 69 of BNSS that corresponded to section 67 of the old code, dealing with the service of summons outside local limits. Now, considering the use of technology for service of summons provided under section 64 of the BNSS, similar provision for use of electronic communication could have been provided under this section also. Another interesting change brought in BNSS is the role of the prosecutor. A responsibility is cast upon the prosecutor to monitor certain cases and examine and monitor police reports. Section 27, subclause 7, subsection 7, Section 20, subsection 8, and Section 20, subsection 9 provide for such monitoring, examining, and scrutinizing. As per Section 20, subsection 7, where offences are punishable for 10 years or more or with life imprisonment or death, the director of prosecution is expected to monitor such cases. Furthermore, he is expected to expedite the proceedings and give opinion on filing of appeals in such cases. In section 20, subsection 8, director of prosecution is cast upon with a duty to examine and scrutinize police report and monitor the cases in which offences are punishable for 7 years or more but less than 10 years for ensuring their expeditious disposal. Under section 20, subsection 9, the assistant director of prosecution is given the responsibility or duty to monitor cases in which offences are punishable for less than 7 years. Effectively, reading these sections, it would be revealed that prosecution is expected to monitor and expedite cases, all the cases in fact. So far as examining and scrutinizing of police report is concerned, such scrutinization or examination is limited to the offences punishable with imprisonment for 7 years or more, but less than 10 years. Another distinct change brought in the BNSS is doing away with the Metropolitan Magistrates Court. Earlier, there was separate demarcation of Metropolitan Magistrates Court according to the metropolitan area. For instance, the city of Mumbai has metropolitan magistrates spread all over its geography. With the introduction of BNSS, even the metropolitan cities like Mumbai will have same category of magistrate courts that we see in the district places. Thus, there is no section that corresponds to the section 8 of the old code that dealt with the metropolitan areas. Even the proviso with respect to the metropolitan area under section 7 of the old code is removed in the new corresponding sections. Consequential amendments are made in other sections also. There are no sections in the BNSS that corresponds to section 16 to 19 in the BNSS as they dealt with the metropolitan magistrates. Some noticeable changes are made in the provisions dealing with arrest. if a person is infirm or is above 60 years of age, then prior permission of an officer not below the rank of Deputy Superintendent of Police will be required if the offense is punishable with imprisonment of less than 3 years. This is a positive move to avoid undue harassment, which is at times caused to senior citizens of the society. This change is brought in section 35 of the BNSS, which corresponds to section 41 of the old code. Handcuffing is now allowed under section 43(3) of the BNSS. The nature and gravity of the offense, amongst other reasons, is to be kept in view while handcuffing. The offenses are listed in the section that would empower the police to handcuff the accused. So there is a section which lists those offenses. There was no such corresponding section or provision in the old code. The object of the legislature to expedite the investigation is reflected in section 53, which deals with medical examination of the accused. It is made mandatory for the registered medical practitioner to forward the examination report to the investigating officer without delay. This provision was not part of the earlier corresponding section. Additionally, if required, the medical officer or the registered medical practitioner can conduct second examination of the arrested person. This provision of second examination was not part of the corresponding provision in the old code. Section 107 of the BNSS is new addition. There was no section for attachment of properties derived or obtained from criminal activity in the old code. Section 107 provides for attachment, forfeiture, or restoration of property derived or obtained from criminal activity. The police is given an option to seek attachment of property, and the power is given to the court of the magistrate to entertain such application for attachment. The section provides a detailed procedure of attachment. There are some special statutes that provide for attachment of properties. Some statutes are state laws. The BNSS gives some extra power to police by making persons bound to conform with the lawful directions of the police. The section 172 of the BNSS, which does not have any corresponding section in the old code, gives power to police to detain or remove any person resisting, refusing, ignoring, or disregarding to conform to the lawful directions. What would amount to a lawful direction is left open-ended, and it will depend on the facts and circumstances of the case. It would have been better if this section would have used words like directions that a police is empowered under any law for the time being in force in India, instead of using the phrase lawful directions. Because what will happen is there is every chance of police to misuse this power. Therefore, lawful direction is a very wide and open-ended term. It would have been better if some particular words restricting those directions of the police would have been used. It would have been better. Hence, I said that a section would have been better if the use of words like direction that a police is empowered under any law for the time being enforced in India. So that is what I feel could have been a better way of drafting the particular legislature. The most important section that provides for one method through which criminal law can be set in motion is changed. Section 154 of the old code is now section 173 of BNSS. While major portion of the section is the same, barring some structural changes, a slight modification is made with respect to cognizable offenses that are punishable for 3 years or more, but less than 7 years. In this particular category of offenses, that is 3 years to 7 years, provision of a preliminary inquiry is made. There is a time limit of 14 days given for this preliminary inquiry. Another change in this section is allowing information to a police officer to be given irrespective of the area where the offense is committed. Now, such practice was done even in the old code when it was in force. Police would usually register a zero FIR and then transfer it to the police station which is having the jurisdiction. So, though this was not mentioned in a particular section, zero FIR was not mentioned in particular section, but it was a practice. A very useful provision under section 185 is added in the BNSS, which did not exist in the corresponding section 165 of the old code. In this provision, which is with respect to search by the police officer, the police officer is mandated to record the search through audio, video, electronic means, preferably by mobile phone. This may bring more transparency in the search, but there is no specific configuration provided for the devices to be used. Unlike in the other sections, this section does not put the responsibility of making rules with respect to such search on the state government. In the same section, that is section 185, the intention of legislature to expedite investigation is also visible, where it says that copies of records made with respect to the search are required to be sent to the nearest magistrate within 48 hours. So this is a good thing. But no time limit is appearing in section 193 of the BNSS. That corresponds to section 173 of the old code dealing with the police report, commonly known as the chart sheet, except a 90 days limit is given for the informing the progress with respect to certain category of offenses. Apart from section 154 of the old code or section 173 of the BNSS, that provides a method of setting criminal law in motion. Another provision under which the criminal law is set in motion has undergone a change. Section 200 of the old code, which corresponds to section 223 of the BNSS, it deals with examination of complainant. It is understanding in the criminal procedure that a magistrate is said to have taken cognizance of offense at this stage, that is when complainant is before him with the complaint. A proviso is added to this section 223, which corresponds to old section 200, and that proviso makes hearing the accused mandatory before cognizance is taken. Now, the word cognizance as such is not defined anywhere in the code, in the old code or even in the BNSS. There is no indication in the section with respect to how the notice is to be issued. There is a cap of 30 days put on the court to give judgment from the day of completion of the arguments. This time is extendable to maximum of 45 days. There is no indication in the section 258 of the BNSS as to what happens if the judgment is not delivered in that time period. Now, similar change is brought through section 392 of the BNSS, which corresponds to section 353 of the old code. Though there is no extendable timeline given for passing of the judgment in section 392. The judgment has to be passed not later than 45 days after termination of the trial. Furthermore, the copy of the judgment is required to be updated within 7 days. There is no change in the provision with respect to appeals and revisions brought in the BNSS. The provisions of appeals and revisions are more or less verbatim to the old code. No provision similar to that of section 392 of the BNSS is brought for judgments in appeal or revision, and as such there is no time limit set on passing of judgment in appeal or revision. One thing which I felt could have been done in the provisions of appeal was putting some kind of restriction on the provision of bail and suspension, because time and again Supreme Court in various judgments have expressed that if for more than 10 years the person's appeal, the accused, the convict's appeal is not being heard, then he is entitled for bail. But though the words of Supreme Court are also matter of record and hence law in India, but those are not strictly followed by the courts. So many times it happens that a life convict is behind bars for more than 10 years and his appeal is not heard. In such cases, it would have been better if the expressions of Supreme Court would have been translated in the legislation under the provisions of appeal. That would have helped in better administration of justice and to to take forward the cause of justice and the entire criminal justice system to have fair opportunity for the convict also to have his appeal heard uh, in a particular time limit set under the appeal provision. The BNSS provides for completing the proceedings even if the accused is absconding and has been declared as a proclaimed offender, even in his absence. Section 356 provides for a procedure that a court has to follow in order to proceed in absentia of a proclaimed offender. Thus, court can convict an accused in absentia. Appeal can be filed only by a proclaimed offender himself by being present before the court himself. Additionally, there is a 3-year limitation on appeal against such conviction. There is a new provision with respect to mercy petition brought under section 472. It provides for the procedure of filing a mercy petition before the President of India or the Governor. The provision with respect to bail has slight modification. The provision that dealt with the bail of under trial prisoners under section 436A of the old code has been modified. The corresponding section in the BNSS is section 479. First time offender have been put on a separate pedestal. For a first time offender, grant of bail is set after having undergone 1/3 of the maximum period of imprisonment specified for that offense. For offenders who are not first time offenders, grant of bail is set having undergone 1/2 of the maximum period of imprisonment specified for that offense. The provision of bail under this section 479 of the BNSS does not apply to offenses punishable with death or life imprisonment. The pre-arrest bail provision undergo pertinent change. The provision of interim bail for the grant of anticipatory bail is not to be found in the new section 482 of the BNSS. Rest of the provision with respect to anticipatory bail are similar. The provision with respect to custody and disposal of property pending trial has been modified. Section 497 of the BNSS, which corresponds to section 451 of the old code, makes the process time bound. These properties are commonly known as the muddemal properties. Apart from making the process time bound, photographs or videographs are required to be taken of those properties. All in all, BNS is one more attempt of the legislature to improve the criminal justice system in the country, and it's hoped that the process will be streamlined. We are done with the discussion on BNSS. Thank you. Namaskar.